DZRJ-810 AM, the voice of the Philippines, proudly brings you Equal Justice. Find out the hottest legal issues of the week and hear the analysis. And now, here are your hosts, Attorney Ador Tolentino.
Yes to peace, no to BBM. Facebook. Okay, if you want to follow me.
Attorney June Kicho.
Kailangan ano pa yun, comfort level eh.
Exactly.
And Attorney Tiki Tabuhara.
Vice President Binay, pati si Pinoy, pati si Executive Secretary, Chief.
While waiting for us to connect with our friends there in Lawag City.
Ano muna? Legal muna.
Tayo dito.
Sa legal muna, legal.
Okay, pare. News. This is really historic din kung pinag-uusapan natin in terms of the legal landscape. Pare, the first conviction under the Anti-Hazing Law has been issued or promulgated by the Supreme Court. And this involves the hazing of a neophyte, of course, who died. And this involves members of the fraternity Alpha Phi Omega.
Naku,
Apo.
Yung ba sila Binay?
Oo nga.
Baka may issue. Kasi, well, sa akin naman kasi, no, itong mga anti-hazing na to, it's been ever since, no, nandiyan naman sana natin yan sa kultura ng mga university students. No? In fact, during our time in the 80s, 70s, may mga
matindi yan. Wala pang anti-hazing law on TV. Remember? Wala pang anti-hazing law at that time. So parang lahat ng mga fraternity were free to just inflict physical harm or whatever upon their neophytes.
First conviction affirmed by the Supreme Court of the anti-hazing law, lahat kasi inaayos yan di ba? Inaayos yan.
From the first level,
maraming
nasa
inaayos
investigation level pa.
Meron recently sa Antipolo, di ba? Inaayos na rin yun. Tapos yung sa, meron dati years ago, I remember, humawag din kami kasong ganyan yung, I think San Beda fraternity din yun, na ano din sila nag-plead guilty sila to a lesser offense and then nag-probation yung mga bata. So, walang nakulong.
Itong mga na-convict kaya, Tiki, hindi sila, they didn't take the stand to disclaim any participation. Actual participation, they could have admitted, yes, identify sila nasa resort, but
Pero partner, ang mahirap dito sa anti-hazing law, no? If you read the law, no? Mere presence is sufficient to render you liable.
Yun nga lang.
At tapos ikaw po may-ari ng resort o may-ari ng venue, kasama kami dyan, no? And then the school can be subsidiary liable.
You know, the drafters and crafters of the anti-hazing law really make sure na
matindi talaga.
Na parang walang kawala. Kasi if you are so strict in the requirement to establish proof beyond reasonable doubt, yes, that is still the quantum of proof that we need. But the way the provision is crafted, hindi na niya dinidemand yung actual participation na in full detail, in technicolor details na maikwento kung ano ang naging participation bawat isa.
Partner,
mere presence.
Partner, ang import natin dito, which is what, itong mga bata na nakikinig, no, yung mga fraternity na yan, no?
Yes.
They have to know that under traditional criminal law, it is only the act or participation or direct act of the accused which will render him liable for the crime.
Yes.
Diba? Ganun yun traditional sa revised penal code natin, gano'n. Pero ito, special law ito And what the crafters of this special law made was that under the anti-hazing law, if you are actually just present, no?
Yes.
Present, you participate, you don't participate, you just watch.
And somebody pointed to you that you were there.
Nakita ka ng maid, nakita ka ng security guard, ikaw may-ari ng lugar, kahit hindi ikaw tumira
Exactly.
Kahit hindi, you did not hit the person.
Kasi theory of conspiracy kasi.
You are liable.
Oo. Under conspiracy theory kasi ito So, kung ikay na may nandun pero walang pumicture sa'yo, walang naka-identify sa'yo, out ka unless pinagkanulo ka rin ng kasama mong na-convict.
Oo. And medyo kaiba yung doctrine kasi normally, as I said, no, direct participation is sufficient to make you liable. Pero dito kahit wala kang ginawa nanood ka lang, kasama ka na.
That's true.
Diba? So, mere presence sa mga initiation is already sufficient kung may namatay.
Yeah. Pero hindi kaya yan, will that not open Tiki? I'm thinking, kasi that seemed to be a very, very loose requirement to an easy way to convict fratmen, under the Anti-Hazing Law. Can that provision of the Anti-Hazing Law be not subject to test of constitutionality?
Dapat.
And also, pwede mo siyang under rules of procedure, you can demand for bill of particulars. Kasi anong particular act that is attributed to me as an accused, di ba? That may have rendered contributory to the fatal blow that eventually led to
that was the argument in the Lenny Villa case. Kasi sabi ng iba, itong sila, mga ibang sabi, nandun lang naman ako Hindi naman ako tumira Pinitik ko lang sa tenga. Pero wag ganun, di ba? But the sentiment of the court now is to make everybody who participated, regardless of the degree of your participation, liable. Yan ang problema
Regardless of degree or extent or actual.
Kahit sabi mo, pinitik mo lang yan, pinitik mo na sa tenga yan, kasama ka na doon kung namatayan. So, it's unfair, no? Pero kung tutuusin mo, it is fair in a sense na
from the point of view of the victim.
You are all participating in doing it So, who dealt the fatal blow, we'll never know di ba? But you are all liable if you acquiesce or agree to that kind of treatment to the victim. Di ba? Ganun di ba? Yan ang reasoning So, if I remember correctly, nung Lenny Villa case, katakot-takot pa na di ba? Mga maniobra.
Kasi the personalities involved, Tiki, hindi basta-basta. The family of the victim himself, medyo mataas-taas sa mga...
Anak ni... Brad natin. Tatay.
Saka sa BIR siya dati.
Si Francisco Villa? Si Romy Villa. Romulo Villa. And then, what is...
official siya sa gobyerno before.
Parang General Counsel Philippines yata siya, yung law firm niya.
At that time na na nagkaroon ng ganyang insidente, nakaupo pa sa gobyerno si Brad Romy.
And then, in credit to Brad Romy, I think he passed away already,
Yes.
He never blamed his own fraternity, Kasi, rin siya, member din siya ng Sigma Rho, but namatay yung anak niya sa ibang fraternity, sa Ateneo fraternity. He never blamed his own fraternity, He never renounced our fraternity and naging faithful pa rin siya.
Wala namang reason.
Pero ito, one more thing I would like to mention is that yung conviction do sa Lenny Villa case, na-affirm noong 2012 or some thereabouts. And nakulong talaga yung mga participant except na mababa lang yung kulong nila. I think 1 year or 6 months na binigay because of meron ba itong mitigating circumstance noon because ang binigay sa kanila ata homicide to reckless imprudence, then may mitigating pa. So ang binigay sa kanila physical injuries lang So 1 degree lower yata ang binigay. So they got out after 6 months.
Anong tawag nila sa US yan? Yung parang unintended
parang reckless imprudence ang nangyari yata sa kanila. Because that was the only thing. Hindi pwedeng homicide kasi there was no intent to kill So I remember yung judge na sa Caloocan when that case was being tried, that was Judge Adoracion Angeles, di ba? Medyo may problema pa yata yun, medyo maraming galit sa kanya. And parang ngiring defensor type siya, di ba? Kinonvict niya yung mga fratmen yun on homicide. Na it was overturned later on by the Court of Appeals na dapat reckless imprudence lang.
Basahin ko lang itong portion na ito ng affirmation ng Supreme Court dun sa Court of Appeals decision, also affirming the trial court's decision, Kiki. Ito medyo disturbed din ako dito because of the quantum of proof that is always required in a criminal conviction. There was prima facie evidence of the petitioner's participation in the hazing because of their presence in the venue. Because of the uncontroverted prima facie evidence lagi ang mini-mention against the petitioners, it was shown that they performed an overt act in the furtherance of the criminal design of hazing. Imagine, uncontroverted prima facie evidence.
Well, mukhang hindi nila dinay. Hindi nila dinay.
In other words, they did not offer any evidence.
Alibay.
Exactly. So that's the danger also when you keep silent. When you should not keep silent, di ba?
Well, partner, mahirap naman kasi mag-offer ng alibay. Kung talaga nandun ka talaga, di ba? Nakita, 10 people saw you, tapos sasabihin mo nandun ako sa Makati, di ba?
Kasi,
di ba?
take the safe, di ba? Sige, yung mga hindi mo brad, sabi nila nakita ka doon. Pero in the actual hazing rights, wala namang magwi-witness na ikaw ay sumuntok o tumadyak o pumadel, di ba? So, may ka na doon sa actual di ba?
Pero,
sabihin mo na I did not. I was in fact just drinking.
Kahit denial lang. Pero,
exactly.
Tanda no partner, yung sinabi dito sa Supreme Court na even if they were not directly pinpointed by any witness, the totality of circumstantial evidence is sufficient to convict them.
Yeah.
Medyo mabigat yun, ha? Medyo mabigat sa akin.
Exactly.
Kasi
Exactly.
this is not only a criminal case, but it is a capital offense case.
Exactly.
So medyo yung quantum of evidence required to sustain a conviction in a capital offense case is much greater than regular physical injuries lang tsaka mga magnanakaw dyan, di ba? So, medyo it's a bit kaiba sa akin, no? And I know this will be contested in years to come. They'll try to revisit the same decision.
Sure. But meantime, since it's already
ito na yun.
Landmark case, this would, I believe, for many years from now, it will stay as, as the basis for
future cases,
prosecution of accused or people involved in hazing.
And it will make the prosecution's job easier.
Kasi
you do not have to present evidence dito sa hazing act.
But
direct participation.
As a criminal law practitioner, I would have I think
questioned.
Ang dami ko pwedeng questionin dito.
Kasi number one,
bill of particular sa akin, ha?
Well, ako
Kasi how can I offer a intelligible defense if a specific act is not attributed to me or described in particularity?
Well, that's what you call bill of attainder. Di ba na parang you're convicted without any proof or any trial? Diba? Kasi sasabihin mo, you were present, wala ka naman ginawa. Kinonvict ka.
Exactly.
That's a bill of attainder, di ba? Parang ganun yung lumalabas eh. Pero let's see, no? Kasi if there's any, wag naman sana sabihin, no? Pero pag may incident na future, let's hope that this will be revisited, no? Kasi
because as we speak right now,
kaiba.
Alam natin na marami pang ganyang pending cases
under
trial and or appeal or review by the appellate courts. Meron pa yan eh. May mga sumusunod na yan. Kasi dami-daming incident na even after the Anti-Hazing Law became.
Madami. Actually, yung Sanbeda, meron pang Alpha Phi Beta.
Yes.
Meron pang marami. Actually, ang daming, if you look at the survey of the cases, marami talaga. Ateneo, meron din.
Yeah. In our case, okay na, no? I think there was already a settlement.
So, maraming cases na usually inaayos yan eh.
Yes.
Because, as you said, in any fraternity hazing incident, there's really no intent to kill. Ayaw na patayin.
I-ano natin yung word na ayos. Meaning, there is a talk of settlement.
Well, it's a compromise. Diba?
Compromise with the family of
acceptable naman. Kasi, ang sa akin na kasi...
Parang nag-o-offer naman ng blood money yung mga...
It's not just blood money, but it's more of a... Hindi mo na may ibabalik yung patay eh. Yun ang sinasabi ko eh. So, the dead man is already dead. So, the next best thing that you can do to resurrecting him is to compensate the family.
Yes.
Compensation na lang kasi wala nang ibang... Pero yung ibang matigas na ganito, they refuse to accept compensation. Gusto pakulong, what can we do, di ba? If I understand correctly, partner, yung meron tayong case din na tayo naman ang nag-prosecute yung Dennis Venturina.
Yes.
Hindi hazing yun.
Well, hindi hazing kasi rumble man. As a byproduct of the rumble, direct result.
Pero convicted din yun.
Convicted. Yung Scintilla Juris fratman na identified assailants of our Brad Dennis Venturino. Alright, so fratman and students of law, watch out. This is a good case study.
It's a good lesson.
Good lesson.
It's a good lesson. In fact, I remember...
Mga nagtuturo ng criminal law dyan, okay? Meron na kayong basehan ng...
Lalo yung magalit sa frat. Takutin mo na. Well, ako naman, I noticed, because I'm also an alumni advisor of some other organizations which also have this hazing, hazing sa UP, So, I noticed na in the last decade or so, or 15 years, medyo naging mahinahon na. Hindi na katulad ng dati na talagang papaluin mo yung tao, susumpuin mo yung tao. Ngayon, it's more of mental na lang, physical, patatakbuhin ka, gano'n, magsisignature sheet ka, you go out around to different members, but not yung talagang papaluin mo talaga yung tao, bubugbugin mo. Hindi na gano'n eh, parang hindi na yata uso ngayon. That's what I noticed.
Let's continue with our discussion on the Supreme Court ruling granting bail to Senator Enrile
and its implication, okay, in our jurisprudence and criminal rules of procedure after this very, very short break from our studio. We will be back.